Well, welcome everyone, and thank you for coming to this first part of family business succession for the water well industry. And this is the first of a four-part series. Today, I'm just going to do a really broad overview. And I'm going to touch on a lot of the topics that we're going to get into a lot more detail later in this series. On July 16th, we will talk about how you title your property, whether that be joint tenants with right of survivorship or sole ownership or tenants in common. And one way that you can title your property is in a business organization. So we'll talk about business organizations and business agreements. Then on August 6th, we will talk about estate planning, wills, powers of attorney, trusts, and documents of that nature to get your estate in order. And then on August 27th, we're going to talk about different types of insurance, and I'm going to try to tie everything all together for you then. We're also really excited that we've got a financial planning expert, Alex White, and in September, we'll get you these dates at a later time, but in September, Alex is going to be talking about retirement planning, which is an integral part of family business succession as well. And he's going to talk about financial planning. How do you talk to a banker when you're going to go get a loan? What type of ratios and numbers do you need to look at? And try to interpret what the banker is telling you. So when you take all of these 6 parts together, it's a very comprehensive look at family business succession. I'm really excited about it. I get to work with a lot of family businesses across the country when they're coming to that very difficult point where the owner of the business or the main driver of the business is getting close to retirement age. Usually people wait until it's getting close to that time, and they need to decide what's going to happen when they decide that they're not going to be an active part of the business anymore, or when they pass away, who's going to take over the business. And a lot of times they either haven't identified that successor, or maybe they assume that a family member is going to take over, but they really haven't talked about that. So this is a really interesting area. While we're going through this today, you can see your chat box at the bottom of your screen. Type in any questions that you have, questions that we think I should answer right away. I will try to answer right away, but we'll also save a little time at the end so that we can catch up on questions, or if you have any new questions, feel free to ask those at that time. And I do hope that you will answer questions. So with that said, one more thing before we get started. We also have a publication at Water Systems Council on family business succession for the water well industry. And it is an overview booklet that goes very well with this presentation today. Contact Water Systems Council if you would like a copy of that publication. And I'll bring that up in future presentations as well. So with that, let's get started. What I'm going to talk about today, some really basic things. I'm going to talk about 5 Ds. You always like to come up with some basic principles that all start with the same letter. And I've got 5 of those, and we'll talk about that. I'm going to talk about some major issues that you're going to run into in family business succession planning. As I said, we're going to talk about estate planning. We're going to talk about business entities. Should you be a corporation or a sole proprietorship or an LLC? One of the really important parts of business is business agreements. And that's where you can tailor that business to your family and the goals that you want to achieve. And since this is an overview, I'm going to kind of give you, borrowing off of David Letterman, my top 10 tips or the top 10 mistakes that a lot of families make in their succession planning. And then we'll conclude and see if there are any questions. So let's start with the 5 Ds. And sometimes I feel like the Grim Reaper when I talk about the 5 Ds. But often lawyers have to talk about things that aren't pleasant. I know people say that they hate going to the dentist, but they probably hate going to the lawyer even more. And all of the 5 Ds are the things that we need to address in your estate planning, in your business organization, and things of that nature. Death, that is something that we don't like to think about, but it's going to happen to all of us. And when that happens, what's going to happen to that family business? We need to think about that. Disability. What would happen if one of the main people in the business would get injured and would be unable to work, perhaps for a month, 2 months, 6 months, or maybe never come back to work again? How would you handle that? Divorce. Some people tell me that divorce and death are the same thing, but they're very similar in some ways. That is a very painful experience, and probably the quickest way and one of the most common ways that family businesses come to an end is because of a divorce. So how are you going to handle a divorce in your business? The next one is another one that's difficult to talk about: disagreements. I can't see you all, but I can imagine that a lot of you are saying, oh, our family never has disagreements. We agree on everything. That's not most families. Most families are going to have disagreements. And then the final D is disaster. And that could be a fire or a flood or a COVID-19 pandemic or some event that has a huge impact on your business. And what would you do if a fire burned down the building and damaged your well drilling equipment? How would you deal with that? Do you have insurance that would cover those issues? And then and the 5 Ds are a good way to think about family business succession, but what are some of the main issues that come up when you're transitioning the business? And the number one issue, and I think you all will probably be surprised about this, is communication. Families, in my experience, often do not communicate with each other. And you all are busy. And what's right in front of you is that job that you have to get done, or you had some machinery breakdown, you've got to deal with that. And when you get to the end of the day, the last thing you want to do is sit down and chat with with other family members. But what I see over and over is that mom and dad will tell me that our daughter Mary, she wants to take over the business. So that's all taken care of. You talk to Mary, And she tells me, oh, I have no intention of continuing in this business. Or maybe it's the opposite. Maybe you think that Bobby doesn't have any interest in the business, but he really does. But you just never talk about it. And so those issues never come up. It's really important to talk about it. The other thing that comes up a lot is most people want to treat their children equally. And that's certainly understandable. But your family business, some of you perhaps have a business that can support your 3 or 4 children all at the same time. But a lot of small family businesses can support one family. And so if the business is going to remain viable, you need to pick that child who is both capable of taking over the business and wants to take over the business. And that, that issue of equal versus equitable really is a difficult one. Because if you give the business to one of your children, then how about the other children? What do you do? And we'll talk about some ideas of how to deal with that. And that includes things like life insurance or other ideas. But I guess the other point is if you leave the business to the children equally, often that becomes a big fight and the business will not continue as well. Another issue that I see over and over again is that the senior generation has control of the business and they want to keep control of the business. They don't want to give that up. And so they might transfer some of the assets to the younger generation. But it's still mom and pop who decide when to buy that new drill rig. And they just come back when they're at a show, they come back and they tell the kids, oh, we bought a drill rig. Oh, really? Why didn't you talk to us about it? Or make some other major decisions in the business. You have to transfer control of a business to that next generation at some point, and you have to plan on how to do that. One issue that I've listed as a major issue that's really not a major issue is taxes. They are not the issue. Back in the olden days, there was $1 million estate tax exemption, and a lot of businesses, particularly if you own a lot of real estate, would go over that 1 million. And so that was an issue. Today, the estate tax exemption is $11.4 million. So mom can leave $11.4 million worth of assets to the next generation, tax-free. Dad can leave $11.4 million worth of assets to the next generation, tax-free. Combined, that's $22.8 million. If any of you have a business worth more than $22.8 million, please contact me. I can help you out. But if you're over that number, you have to do some serious planning. Most businesses are going to fall under that number. And that's a good thing. You can do what you want to do instead of worrying about avoiding taxes. There's also a $15,000 per year per donee gift tax exemption. So if I do have a lot of assets, or maybe I just want to transfer some assets to my children or my grandchildren while I'm still alive, I can do $15,000 per person, like each of my children, I can give them $15,000 and nobody pays taxes on that. Mom and dad can get together and each do $15,000. That means you can do $30,000 per year per child or grandchild, your favorite lawyer, whoever. So that's another way that we can get assets out of your estate. So let's now go to a very general overview of estate planning. And like I said, on August 6th, I'm going to be talking about estate planning in a lot more detail. But just to kind of give you a taste of it now, some of you are going to be surprised that the first item that I list on estate planning is power of attorney. And like I said, I will talk about this in more detail later. But for purposes of our discussion today, probably if there's one thing, well, I don't want to say that. One of the most important things you should take away from today is that every single person that's hearing me talk right now needs a power of attorney. While you're alive, your executor under your will has no authority at all. While you're alive, your spouse does not have the authority to transfer your assets or to manage your financial affairs. If you're under 18 years old, your parents have that authority. But once you hit the age of 18, you're an independent person. If any of us were to become disabled, incompetent, there's nobody around to manage our affairs. That's what a power of attorney is for. The power of attorney can manage your financial affairs. Without a power of attorney, you would have to go to court to have a guardian appointed. Much better option is a power of attorney. Advanced medical directive or living will is the second item on my list. Again, you might be a little surprised about that. But the advanced medical directive and living will is very popular these days. This is where, in advance, while you're still around and you're still healthy and can still manage your affairs, you can give instructions to the doctor and say, if I am in a state where I need medical attention and I can't make those decisions, here's what I want you to do, doctor. Here's how I want you to take care of me if I can't say so. You can also appoint people who can manage your affairs for you in that medical setting. And so that's a very important thing to do. The next item, and one that you all have probably heard about, is a will. And the will is a document that appoints a guardian for your children, distributes your property, appoints an executor. And that's an important document as well, but not, in my opinion, some people, if you're a young person, if you're a person who doesn't have a lot of assets, you might not need to have a will, or the will is not as important as it may seem to be. And finally, a trust. And we'll talk about trust more in August. But a trust can be an important feature of your estate plan. So the next thing that we want to talk about today, I'll talk a little bit more about power of attorney versus a will. I've already talked about the fact that the executor does not have any authority until you die. And as a matter of fact, the will itself is a worthless piece of paper until you die. During your life, the operative document is the power of attorney. And so think about what would happen if you would become disabled and you don't have a power. Now I want to turn to the topic of who is entitled to your property after death. And again, a topic that we will talk about more at a later time. But does your spouse have a right to some of your property when you die? What if you have a will that leaves all of your property to somebody else other than your spouse? How about your children? Are your children entitled to anything upon your death? I'll give you a little bit of a hint before August. The answer is that your spouse is entitled to property. Your children are not entitled to anything. What happens if you die without a will? And I said that a will is important, but maybe not as important for younger people without assets. One of the things I hear a lot is that if you die without a will, your property goes to the state. But that's not the case. Actually, the state has developed an estate plan for you. And the state says, if you die without a will, here's who gets your property. And that's mainly going to be your spouse and your children. And the mix of that depends on a few different things, and it depends on what state you live in. But the state does not get your property. The problem is that maybe the way that the state distributes your property, not necessarily the way you want your property. And the state would have to appoint a guardian for your children. You have to get an executor. So those are some of the reasons that you want a will. If you don't have a will, the state will make those decisions for you. I talked about gifting. And again, we'll talk more about this, but should you give some gifts during your lifetime? Well, something that a lot of you have already heard from me, maybe you've heard from another lawyer, but the lawyer's favorite answer to any question is, it depends. Should you give gifts during your lifetime? It depends. The estate tax used to be a concern, but no longer is for most people. So you don't have to worry about taxes, probably. One thing that a lot of people are concerned about is control. I do hear a lot of people say, for example, in case I go into a nursing home, I don't want them to take my house. So I'm going to go ahead and give my house to my kids while I'm alive and while I'm not in the nursing home, so that the nursing home can't get my property. There are several different problems with that. One being that the state can look back at least 5 years and maybe longer to transactions like giving away your property. And pull that back in consideration of who should pay. But also, once you give something away, you have no more control. Well, I have seen situations where parents have given something to their children for that nursing home purpose or other reason, and the kids kick them out of the house. So you have to think about it. But there are other things that maybe you should give. Maybe you have a child who is going to college or a child who is buying their first home, and they need something today, and you're in a position to give it to them today. Maybe in that situation, you should give it. And I'm going to mention something today that I'll talk about more in August. It's kind of a complicated issue, but I can't avoid it, so I'll talk about it. And that is stepped up basics. And if there are any accountants listening, I apologize for making this oversimplified. But basically, when you buy something, the basis of that property is what you paid for. If we use real estate, I'll buy the real estate for $100,000. Basis is $100,000. If I sell that real estate 20 years later for $500,000, I have a capital gain of $500,000 the sales price minus $100,000 the basis. I have a capital gain of $400,000. And I will pay capital gains. More importantly, perhaps, it depends again. If I gift something during my lifetime, whoever I gift it to has the same basis that I did. So I have that land that I purchased for $100,000. I gift it to my child. They sell it for $500,000. They have to pay capital gains because the basis is also $100,000. So why does this matter so much? It matters because Uncle Sam does all of us one big favor. But Uncle Sam, you have to die to get that thing. When you die, the basis of all your property stepped up to the fair market value of the property at the time of your death. Let's go back to my real estate example. Bought it for $100,000. It's worth $500,000. Now, instead of gifting it to your child during your lifetime, you die and you leave it to the child at your death. The basis of that property is $500,000, the value at the date of your death. Your child turns around, sells it the next day for $500,000. How much capital gains tax does your child pay? And hear some of you saying zero. That's the right answer, zero. Nobody ever pays the tax on that $400,000. Magically disappears. Now, for a lot of your businesses, let's talk about a well rig. You buy that well rig for $500,000, but you depreciate the well rig. And so, in a relatively short period of time, you depreciated it down to zero. And the basis of that well rig is zero. So if you or child can gift it to your child, the basis is zero. If you sell it, you have to pay a capital gains tax. At your death, the basis gets stepped up to whatever the fair market value. So that's an important concept. We'll talk more about. So the bottom line is, if I'm going to gift something during my lifetime, probably want to gift something like cash. Because it has a basis of whatever the cash is. So I don't lose that stepped up value. I do not want to gift things that have a low basis or zero basis, or that's going to appreciate in value in general. So now let's turn to business things. And I'm going to tell you a lot more about business entities on July 16th. Today, I just want you to go home, stay home with two different principles. The first is a lot of you have probably heard of an LLC, a limited liability. I call them the magic LLC because a lot of people seem to think that they are magical. All I have to do is form an LLC and my creditors cannot get any of my money. The lion and the lamb will lie down together. I'll make lots of money and we'll live happily ever after. And that's really not the case. Limited liability, as we'll talk about more in July, it is a benefit of a limited liability company. A limited liability company gives you some limited liability, and you only pay one level of tax. And that'll become more important when we talk about corporations that have a double tax. So a limited liability company is great as a business, but it's not magical, and it's not going to solve all your problems. I think, at least when you're thinking about your business entity, forget about limited liability. I'm going to tell you some things when I talk about insurance and a little bit when I talk about business agreements that will help you limit liability more than coming up with a limited liability. I mean, there are several different ways that you can limit your liability. Instead, think about your business agreement and what your goals are and what you want to achieve, and focus on that. And we'll take care of the limited liability. The other thing that I wanted to talk to you about, and I want you to take away from this this webinar today, is about partnership. And partnerships also have some tax benefits, and they have some other benefits. They're pretty simple. And if you have two people, probably the easiest way to go is a partnership. But I always say that being in a partnership is worse than being married. And now you don't have to wonder why I'm not married, because I say stupid things like that. But the why I say that I don't want to be in a partnership, regardless of who my partner is because when you're in a partnership, you are personally liable for all of the debts and commitments that your partners incur on behalf of the business. So if I want to use a water well agreement or a contract, let's say I'm in a partnership in a water well contract with a company, and my partner goes to Las Vegas for the NGWA show and having a great time, having such a good time that goes down to the show and commits to buy a brand new top of the line well rig. Has all the bells and whistles. It's the best you can get. Comes back from Vegas and tells you about it. You're like, we don't need another well rig and we can't afford it. And worse yet, Your partner gambled away everything that they owned while they were in Vegas. But you saved your money and you have a lot of assets. Guess who they're going to go after to pay for that well? It's going to be you. Another example might be if your partner has an accident while on site, or maybe while driving to or from the site, there's an accident, somebody is injured. You are personally liable for that injury, for those deaths. So, it can be unlimited. They can come after your house. They can come after your dog. Anything that you own is on the line for that. And the question is whether your insurance will cover that, and we'll talk more about it. But more particularly here, and I don't know how often this happens in the water well industry, but in a lot of industries, especially if you're a small business, you might share things. There might be a special well rig that you and another company share, or, I don't know what the example might be in the water well industry. But if you start working together with another well contractor and you don't have anything in writing, you're probably in a partnership. And if something happens, the court's going to treat you as a partnership, and that can be a really bad thing. Another takeaway with respect to businesses that I want to talk about is business agreement. They are, I think, one of the most important things that you can do to make sure that you reach your goals as a family, and to make sure that your business goes to that next generation, is to have some business agreement. And that's where you really need to sit down and talk and say, what do we want to achieve as a family? What's going to happen when I'm gone? Look at the 5 Ds. What if somebody becomes disabled? What if we have a family feud and we are fighting and we can't agree with anything? What if there's a divorce? What if somebody dies? How can I deal with that? And you deal with that in the business agreement. You should tailor it to your particular business and your particular family. Here's where I'm going to say that lawyers are not always good at this. And if you go into a lawyer and say, I want a limited liability company, most lawyers are going to say, sure, it's going to cost you X amount of dollars. Here you go, see you later. And you need to say, no. I have a small family business. I want to make sure it survives. Here are the things that we want to talk about. What are the responsibilities and expectations? What is the purpose of the business? How are we going to deal with the business? An important part of the business agreement is buyout provision. And that is what we talk about on the next slide, is that one part of your business agreement is going to be what happens if there's a divorce. Does that often in a divorce, the non-family spouse has an ownership interest in the business? So are you going to run your business with your ex-spouse right beside you for the rest of your life? You probably don't want to do that. Or what happens if somebody passes away and leaves a spouse as their survivor, and that spouse is not involved in the business? They are probably entitled to part of the business. A buyout provision can say, well, we want to buy you out. We're not going to give you your part of the business. We're going to buy you out on that. Here's how we're going to decide the valuation. And you can keep the value fairly modest if you follow some rules. And we're not going to pay you, if your interest is worth $100,000, we're not going to write you out a check for $100,000. We're going to do a note to you. We're going to pay it over 10 years at a very modest interest rate, and we're going to do it over time. And there are certain ways that you can use life insurance to fund these buyout provisions. And we'll talk about that later in our series of webinars. The other thing that you want to talk about in your business agreement is what happens when the business terminates or if we sell the business. If somebody dies, does the business stop? Does it continue? How does it continue? And what if one of your kids wants to sell everything? And you've left it to all your kids. One of your children wants to run the business. The other one wants to sell it. Do you want the one child just to be able to dictate that the business be sold? Or do you want there to be a supermajority, like 2/3 have to vote to sell? Who has the authority to sell all of it? And that again goes back to what are the goals of your business? What are the goals of your family? And how do you want to handle these items? The next thing that I talk about with business agreements is something that comes up a lot. And that's protection from divorce. And that's a huge issue. And that goes back to my buyout provision. Most families do not want to have an ex-spouse who is not part of the family involved in the day-to-day operations of the business. So there are certain things that we can do. We can put in the business agreement that only lineal descendants of grandpa or grandma or mom or dad can be owners of the business. And that's enforceable. That can also help you with nursing home issues. And we'll talk more about that. But that keeps people out that you want to keep out. You need to think about adopting kids. I've also heard, well, wait a minute, I have a son-in-law, daughter-in-law that is vital to this business. And under the provisions that you're saying, they can't own the business. Well, you can tailor your agreement. You can say a 2/3 vote to enter the business. So again, these are things that you can talk about, that you can tailor for your own business, and that you should think about when you're doing this. The last thing, and I'll probably talk about this more when I talk about business agreements, prenuptial agreements are becoming more and more common, especially when a family business is in. And that's another way to deal with these issues. The next provision that I'll just mention today, and we'll talk about more in July, is the right of first refusal. And that protects you in connection with, in addition to prohibiting non-family members from being part of the company, you can put a provision in the agreement that says, if you're going to sell part of this business to a third party, you have to first offer to sell it to the limited liability company or the corporation first And then you have to offer to sell it to all of the existing owners, all at the same terms and conditions that you would sell it to that outsider. So that protects you against somebody trying to sell to outsiders at a price that's way below market, or protects you against that family member that goes to Vegas and decides to gamble away their interest in the business. They can't do that. You're protected in that respect. So it can provide some protections to you. So that gives us a general overview of estate planning, of business agreements, of some of the basic things that we're going to talk about with respect to your family business succession. Now I want to go over about 10, I'm not sure if it's exactly 10, but approximately 10 top tips for people in their estate planning and family business succession planning. And these are things that in my law practice I've seen happen over and over again, and they can cause some really serious issues. The first thing is, let somebody know where your estate planning documents are. And I should add, let them know where your business documents are, your limited liability company, your corporation. A lot of times when somebody passes away, we can't find their will, can't find their power of attorney, we can't find any of these documents, and we have to scramble for them. A lot of times, for whatever reason, we find them in a kitchen drawer. I don't know why. The safest place is to keep them in the safe deposit box at a bank. Some lawyers will provide as a service that they will keep the documents in their safe deposit box. But whatever you do, keep it in a safe place and let more than one person probably know where they are in case something happens to you. The next tip is about your safe deposit box. After 9/11, banks became very strict with respect to who can get into a safe deposit box. And we might get somebody coming to the bank and they say, I'm the power of attorney. I can get in. And the bank says, I don't see you on the signature card. I'm not letting you in. Or they say, well, I'm the executor, but the will is in the safe deposit box. And the bank says, well, let me see your certificate of qualification as executor. Well, I don't have it because I've got to get the will first, and it's in the safe deposit box. Well, no, you can't get in. So make sure that you put people on that card, that signature card, and allow them into your safe deposit box. Another mistake that I see sometimes is that somebody appoints people as executor or as power of attorney, and they don't tell anybody, including the person they've appointed. And so when something happens, it's a big surprise. Oh, I'm the executor? I didn't know that. What do I have to do? Or when something happens to you and they're like, do they have a power of attorney? Oh gosh, I don't know. Who is the power of attorney? We can't find the power of attorney, and nobody knows who it is, so we have to assume that you don't. This is also helpful with your children. I've seen situations where mom appoints the oldest daughter as the executor of the will. And when mom passes away, the younger daughter says, I knew mom loved you more than me. So she appointed you as the executive. When really mom appointed the oldest daughter because she's an accountant. She knows how to handle money. It's a good idea to sit down with your kids and say, here's what I'm doing in my will and here's why. And I'm not going to guarantee you that your kids aren't going to be mad at you, but they're really going to be mad at you and they're going to be mad at their brothers and sisters if they don't find out until you're gone and it's in the will. So it's a good idea to have that discussion. And even that discussion of, I'm going to leave the business to Mary, and I'm going to have to name Bill as my beneficiary of my life insurance. And here's why I did that. It's a good idea to do that. Another thing, I know a lot of people in the water well industry own vacation homes in other states and maybe even in other countries. If you own, when you die, you have to go through probate in every state which you own property. So I'm a resident of West Virginia. I own property in West Virginia and in Virginia. I'm going to have to go through probate in West Virginia because that's where I reside and I own property. I'm going to have to go through probate in Virginia, and that's going to increase my costs. So you need to think about that. I will teach you some tricks over the next couple months of how to avoid going through probate in 2 or 3 or 4 different states. But you can still own that real estate. Or some people they think about it and they say, I really don't need that lot in South Carolina. I'm just going to sell it. So it's out of my state. I don't have to worry. But there are strategies to deal with that. The next tip that I have here, and this is one that happens a lot too, the stories I can tell, is life insurance does not pass through your will. So you can have in your will that I want my life insurance proceeds to go to my kids equally. That has no impact whatsoever. They're going to, life insurance is a contract. They're going to look at who you named as a beneficiary, and that's who's going to get it. And that goes to my next tip, and this happens a lot too. People get divorced, things change, events happen, and they don't think about their life insurance. They just pay the bill every month. Maybe it's paid off, so they just don't think about it. I can't tell you how many times I have had an ex-spouse. They've been divorced for 10, 20 years. Walk out to the mailbox one day, and there's a check for $200,000. Their ex-husband forgot to change the beneficiary of the life insurance. And so it's usually the husband that dies first. But ex-wife goes, I never did like that guy, but gosh, $200,000, that makes that years that we were married a lot more tolerable. So when anything happens in your life, go back and look at that life insurance policy. In addition, joint tenancy with right of survivorship property is not impacted by the will. It goes via survivorship to whoever your joint tenant is. So you need to look at your bank accounts at your real estate and see how are they tied. Yet another, if it's in a trust, property does not pass by the will. Property goes to whoever is listed in the trust as getting that property. So be really careful. We're going to talk about that at our next session on July 16th, titling property and how important that is. My last tip of the day, and I hope there aren't anybody in the audience who does this, but I always see in the newspaper, on the local TV channel, that there's going to be a group of lawyers passing through town, and they're going to set up a living trust. And the living trust, I should call it the magic living trust, because you're not going to have to pay any taxes. You're going to avoid probate. Your creditors can't touch it if it's in the living trust. That's not true. Some of you who are listening here today may need a living trust, but my guess is very few of you do. A living trust can be a useful tool, but only in certain limited circles. What these living trust seminars do is they get a fair amount of money from you, you set up a living trust, and then they're gone. And a lot of times it actually hurts you rather than helps you. I recommend going with a local attorney or someone that you can trust, not somebody passing through there, giving us some. So we have a few minutes left. So I will open it up for questions. And I haven't seen any questions yet. If anybody has any questions, feel free to put them in the chat box, and Charlene will forward them to me. While we're waiting to see if there are any questions, I'll remind you that Water System Council has a publication on family business succession in the water well industry. You can obtain that by contacting Water Systems Council. We will talk about titling of property and businesses and business agreements on July 16th. We will talk about estate planning on August 6th. And on August 27th, I'm going to talk about insurance and different types of insurance and how you can kind of tie this up in a bow, get everything together, and get your family succession plan done and in place. And then in September, we're going to get some financial planning and retirement planning advice and help for all of you who are dealing with these issues. I'm still not seeing any questions, so I want to thank everyone, and I want to say that another thing that I want you to take away from today is that, and I know this sounds kind of corny, but today is the first day of the rest of your life. Some of you have not done any estate planning or family business succession planning. That's normal. Most people have not. But you need to start, and you need to start today. So please, if you're at your office now, when you go home, start thinking about it. If you're already home, start thinking about it. And if there's anything we can do to help, let us know. Thank you again, and I will see you virtually on July 16th. Thanks again.